Hello and welcome everybody to today's webinar. My name is Paula Price. I'm with the People's Law School, and today we are talking about evictions and renovictions in British Columbia. We are joined today by four amazing speakers. We have Anil Agarwal and Lisa Mackey from Alexander Holborn, and we have Michelle Crawford and Leon McGee Teitelbaum from the Residential Tenancy Branch. Now, what we will be covering here today, we're going to talk about ways in which a landlord can evict a tenant. We're going to talk about what renoviction means and steps a landlord must follow to do that. How changes to tenancy agreements can bring a tenancy agreement to an end. We're going to talk about how eviction works with roommates who are not on the tenancy agreement. And we will talk about how to deal with disputes and the role of the residential tenancy branch. What you can expect today, we have 60 minutes together. We will be answering your questions. We will be providing legal information, not advice, and that information is current as of today. If what you're looking for is legal advice, in other words, the law as it applies to your particular set of facts, we would encourage you to seek legal advice from a lawyer. You're welcome to contact one of the speakers that we have here today. Their contact information is on the slide. And you're also, of course, welcome to reach out to the Residential Tenancy Branch. Their information is also on this slide. We would like to acknowledge that we're grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we invite everybody who has joined us to think about where it is that they are joining us from. We would also like to acknowledge our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes these webinars possible. And finally, we would love to acknowledge our speakers, and we have four of them today. We are joined by two lawyers from Alexander Holborn and two representatives from the Residential Tenancy Branch. I'll start with Lisa Mackey. Lisa is a lawyer. She is the leader of the Strata Property Group at Alexander Holborn, and she is a return guest speaker to the People's Law School webinars. You may have seen her. She's been here 3 times previously, twice to talk about renting and once to talk about strata. So if those are topics that are of interest to you, I would encourage you to go back and look at those recordings. Lisa, welcome. It is such a pleasure to have you here today.
Thank you so much for having me back, Paula.
Thank you. With us as well is Lisa's colleague, Anil Agarwal. Anil is also a lawyer with Alexander Holborn. He is in the Residential Tenancy Practice Group. We are delighted to have Anil join us here today. Welcome, Anil.
Thank you, Paula. Hello, everyone.
We also have, as I mentioned, 2 representatives from the Residential Tenancy Branch. Now, if the Residential Tenancy Branch is new to you, I will just let you know it is a BC government organization. It provides landlords and tenants with information and dispute resolution services, as well as resources to help both landlords and tenants know their rights and responsibilities. And you'll be hearing more about the Residential Tenancy Branch or the RTB throughout today's discussion. We have Michelle Crawford, who is a manager with the RTB. Welcome, Michelle.
Thank you so much for inviting me. Glad to be here.
We are so happy to have you. Thank you. And we also have Leon McGee Teitelbaum, who is also joining us from the Residential Tenancy Branch. He's an information officer with them. Welcome, Leon.
Thank you. Very happy to be here. Thank you, Paula.
Wonderful. And with that, we are going to jump into today's questions, starting with a question for Lisa. Lisa, what are the key ways that a tenant can be evicted in British Columbia? Can a landlord evict a tenant for being difficult to deal with?
These are great questions. And fortunately, the Residential Tenancy Act makes it a bit easy for us because if we want the answer to the question, we only have to look in one little spot of the act. So if you look at the Residential Tenancy Act, we just have to go to Part 4. And Part 4 outlines all the different ways that your tenancy can come to an end, whether it's landlord initiated, whether it's tenant initiated, or whether you both agree to end your tenancy by way of mutual agreement. So for the landlord side of things, there's a variety of different ways that they might issue an eviction notice to you as a tenant. So they might issue an eviction notice under a 10-day notice for non-payment of rent or utilities. There could be a 1-month notice for cause or for end of employment with the landlord. There might be a 2-month notice for the way in which the landlord intends to use the property. For example, a purchaser is bought and they're going to be moving in, or the family member of the landlord intends to reside in the property. It could be a change in use entirely for the property. It might be a change in the use from residential to commercial, or for changing it to a strata lot. There might be a demolition or significant renovation, and we're going to chat about that a little bit later as well. Wide variety of areas. And so Section 44 is the magic section to start with when we're wondering how my tenancy might come to an end. And if you are struggling with falling asleep at night, crack open the Act, have a read. I guarantee by Part 4, you will be fast asleep. So that's a bonus tip for you today. The question, can a landlord evict me for being difficult to deal with? It depends. And so what a typical lawyer answer? It depends what difficult means. So under the Act, a landlord can end a tenancy when a tenant is significantly interfering with others or unreasonably disturbing others or the landlord at the property, if they're causing extraordinary damage to the property, if they're repeatedly late paying the rent. So it really depends on how difficult you're being and whether or not your difficulties that you're generating actually breach your obligations under the lease or under the Act. You can't evict somebody for just being rude, or you just don't like them. So fast tip for landlords. You don't necessarily have to love your tenants, but if there is a crossing of the line, so to speak, there is an ability for a landlord to end a lease.
Beautiful. Thank you so much, Lisa. This next question is for you, Michelle. And the question is, can you please describe how the laws around renovictions changed in 2021 and the steps a landlord must take if they want to evict a tenant to renovate a rental unit? Does it make a difference if the tenancy agreement is for a fixed term?
Okay, yeah, so the law changed in July 2021. So before July, if a landlord wanted the unit to be vacant to complete repairs or renovations, they could give the tenant 4 months notice to move out. But the law was changed. So now if a landlord wants to evict a tenant to renovate a rental unit, they must apply directly to RTB, to the residential tenancy branch. The landlord has to prove 4 things in their application. They have to prove that the renovation is necessary. So the proposed renovation is not something that is nice to do, such as let's enhance or update the look of the rental unit. The renovation really must be necessary to prolong or sustain the use of the rental unit. The landlord must also prove that the only reasonable way to complete this work is to end the tenancy. They have to prove that the rental unit must be vacant in order to complete this necessary renovation. And then finally, the landlord must have all of the government permits and approvals in place, or prove that these permits or approvals aren't necessary in that particular municipality. And I would just like to note that sometimes permits aren't required to do the work, but there's usually other official documentation that an arbitrator, is going to expect to see related to the requirement that the unit really needs to be empty. For example, if a landlord's complaining that asbestos is the reason that a unit has to be vacant, I'd expect the landlord to include a copy of the hazmat report. That's a hazardous materials inspection report. That's part of the WorkSafe requirements, and I'd expect to see that in their application. So if the landlord's application is granted, the tenant will have 4 months from the date of the arbitrator's decision to move out of the unit. And if the tenancy is a fixed term, the landlord cannot get possession of the rental unit before the end of that term. So to sum up, landlords now have to apply directly to the branch, residential tenancy branch, and the landlord should make sure that their records are in order before they apply to prove that renovation is required to maintain the use of the rental unit. The renovation cannot be done if the rental unit is occupied. Ending the tenancy is the only reasonable way to complete the renovation, and all regulatory approvals have already been obtained to do the renovation.
Super. Thank you so much, Michelle. And does it make a difference if you've got a tenancy and there's a fixed term on it? Do you still need to go through that process?
Well, yes, because in BC now, at the end of a fixed term tenancy, it goes automatically to a periodic tenancy unless the landlord is going to move in. So if the landlord isn't going to move in, it goes to a periodic tenancy. And if they want to renovate the unit, that's not moving in. So yeah, they need to apply to the branch. If I understand your question correctly.
Super. Thank you so much, Michelle. This next question is for Anil. Neil, the question here is, I've been renting an apartment with a friend for 2 years. We're both on the tenancy agreement. She lost her job and can't afford rent anymore. I want to bring in another friend to take her place. Our landlord says that I can't do that my co-tenant leaving means the tenancy agreement is at an end, and so I have to leave too. Is that correct?
Well, great question. And I think just to sum it up, I'll say it all really depends. And so, first and foremost, what I like to do is I like to look at what the actual tenancy agreement says. For example, does the agreement prohibit explicitly occupants from coming into the unit? And I think when you look at the branch's material, they would suggest that if there is nothing explicitly limiting or prohibiting occupants, then that would mean there's an implied ability to actually get occupants. So the first thing is look at the agreement. Then the next question is, well, co-tenancy. What does that really mean? And in a co-tenancy, both parties, tenant A and tenant B, share the responsibilities for that tenancy agreement. They're both equally liable for payments of rent, et cetera, et cetera. And so when one co-tenant engages with the landlord and says, hey, landlord, I'm going to, I'm issuing notice, or I'm going to enter into a mutual agreement to end tenancy, that notice or agreement to end tenancy would apply to both co-tenants, the other co-tenant, despite the fact that the other tenant may want to actually stay within the unit. So if that situation hasn't occurred and the tenant who wants to leave is simply just going to leave the unit, tenant B, who wants to remain there, could technically stay in a unit provided they continue to maintain the obligations of the tenancy agreement as it applies to both parties. Going back to my comment previously about does the agreement prohibit occupants from coming into that unit? Well, if it doesn't, technically, one could say that the remaining tenant could have somebody come live in the property with them, because the agreement doesn't actually prohibit an additional person coming in. So I think what I'm saying there is, just because they have to leave doesn't mean that the other co-tenant has to necessarily leave the unit unless there's been a notice provided to the landlord, or unless the mutual agreement to end tenancy has been provided to the landlord. Alternatively, if there is some dispute or an issue, negotiate with your landlord. The remaining tenant can always negotiate a brand new tenancy with that landlord, provide for new consideration in terms, and that might be enough to at least provide some parameters on what that tenancy looks like, who can enter and exit that unit. And so it really all just depends, but it does not necessarily mean that you have to leave too.
That's great. Thank you so much, Anil. This next question is for you, Leon. I've been renting a suite for a year. My girlfriend has been staying with me for the last little while. The landlord is trying to raise the rent by $250 a month to add my girlfriend to the tenancy agreement. The landlord says if we don't agree, she'll serve us with an eviction notice on the basis that two of us are living in the suite. Can she do that?
Okay, so I don't mean to continue on, but it's also depends, right? It's another depends style answer.
The theme.
It's the theme, I guess, with legal questions. So the first thing you really want to try and identify is the situation of the girlfriend. Is the girlfriend a guest or is she an occupant? So you can kind of distinguish this by whether or not the person, the girlfriend, is simply visiting. If she has an address elsewhere, then she's more likely a guest. And when it is a question of guests, and again, as Anil has mentioned, you'd always look at the tenancy agreement to be sure, but generally speaking, With guests, there should be no intervention by the landlord. If you're having guests under reasonable circumstances, whether they stay overnight or not, the landlord can intervene. Now let's assume that the girlfriend has moved in permanently and she doesn't have another primary residence. This is it. Then we would consider her to be an occupant. And where there's a difference between an occupant and a tenant is that an occupant is not on the tenancy agreement. So they don't have the rights and responsibilities. Now, in looking at the tenancy agreement, if I'm the tenant, my reflex is to just look out for those terms of the agreement. There can be terms that limit the amount of occupants. And by having an additional occupant, I might be breaching that term and risking receiving an eviction notice from the landlord. Another thing to look out for is that there may be a term that indicates that when there are additional occupants, the rent will increase by a determined amount. And that's allowable under Part 3 of the Act. And that escapes the rent increase rules that we're very familiar with, where you get a rent increase on an approved form once every 12 months. If you have that term, it can be active, and then you'll owe more rent. Now, whether or not the tenant has to agree to have the girlfriend on the tenancy agreement, that's something that may need to be negotiated if the tenant is breaching the agreement by having the additional occupant, maybe something they want to explore. But generally speaking, you don't. You do not have to, if there's no term prohibiting the amount of occupants or increasing rent, have to renegotiate. You're allowed to have other occupants. Someone can have a girlfriend or boyfriend move in. And there is one part of the Act that looks at this could be cause if there are an unreasonable amount of occupants in the rental unit. But if we're dealing with two people in a single bedroom rental unit, it would be very difficult to prove from a landlord's perspective that that was unreasonable. So general answer is depends, but the shorter answer is the landlord can increase rent if there's a term that already sets that out, and that's not a problem. If they don't have that term, they cannot increase rent. They have to follow the rent increase rules. They can serve an eviction notice if there is a term limiting the amount of occupants in the rental unit, but if not, they would have to try to prove that it was an unreasonable amount of occupants, which can be difficult.
Super. Thank you so much, Leon. That was very helpful and very clearly responded to. I'm starting to see that distinction then between your guest and your occupant and the difference that that has in terms of what consequences flow. Thank you for that. This next question is for Michelle. And Michelle, it is this. The landlord hasn't been fixing things in my apartment that need repairs. When I've complained, they say I can move out if I don't like the place. It feels like they're trying to make me leave, perhaps so they can increase the rent for the next tenant. Is there anything I can do? Can I stop paying rent until the repairs are made?
Okay, well, to answer the last question first, no, don't stop paying your rent. So with regard to repairs, a landlord should be inspecting the rental unit regularly to determine if it's safe and in good repair. So even if a landlord isn't doing this, tenants should not stop paying rent if they want to continue to live in the rental unit, because the law requires that the tenant pay rent in full and on time, even if the landlord isn't complying with the law. So when a tenant or landlord wants to enforce their rights, you really should deal with each other in writing so that there's a record which can be reviewed if an arbitrator needs to look at this issue if it comes to the residential tenancy branch for resolution. So if you need repairs, I recommend that you ask your landlord for repairs in writing and use the address that the landlord has recorded in your tenancy agreement. You need to explain why the repair is necessary and give your landlord a date that is reasonable for completing the repairs. For example, longer than just over the weekend. They do need a reasonable amount of time to be able to complete the repair. So if the landlord doesn't do the repair after receiving your request and the reasonable deadline that you gave them is passed, you can file an application against the landlord with the residential tenancy branch. And the arbitrator assigned to your dispute will decide if the landlord needs to be ordered to do these repairs. If you do feel you need to apply against the landlord, you should include photographs of the needed repairs, the request that you sent to your landlord, and of course include the landlord's answer to your request if one was received. Now, if you just receive no response, potentially an absentee landlord, double check that you're using the correct address for the landlord on your tenancy agreement. So back to coming to residential tenancy branch, the landlord may indeed be ordered to do the repair if the arbitrator is convinced by the tenant's application that this is necessary to maintain the rental unit and something that should be done. If the landlord still does not do the repair after being ordered to do so, you could file another application against the landlord and ask for your rent to be reduced. You could also take the risk of making the repair yourself and then filing an application against the landlord to make the landlord reimburse you for the repair. And if the arbitrator does find that the repair was necessary and the landlord breached the act by not making the repair, they could order that you are able to reduce your rent to recover the money that you did pay for that necessary repair that wasn't done. But you absolutely cannot recover the cost of that repair by deducting it from your rent without that order from an arbitrator. If you do that, you're giving the landlord a reason to evict you for unpaid rent. And that's a 10-day notice that can be given to you by the landlord because you did not pay your rent in full and on time.
Thank you so much, Michelle. That is a very helpful answer. This next question is for you, Leon. And this is, I gave my tenant 2 months notice saying that I plan to move into the rental suite, but my health changed all of a sudden. And instead of moving in, I sold the house. Now the tenant is saying that they will apply to the Residential Tenancy Board for compensation of 12 months rent, saying that I deceived them, but I didn't lie to get them to move out. Does the tenant have a valid claim?
Yeah, so this is a scary situation for a landlord. So the tenant can have a valid claim. And the way the act is written and the way the compensation is written into the act does put a notice on the landlord to show that they fulfilled their stated purpose. So moving in means moving in within a reasonable amount of time and for 6 months duration. And that same section is section 51 also does allow for there to be extenuating circumstances that excuse the landlord if they can't move in. And so, it'll be up to an arbitrator based on the proof, whether or not they're going to see that there are extenuating circumstances that may have prevented me as a landlord from fulfilling that obligation to move in for 6 months duration. And sometimes, it can be major health concerns. That's not uncommon. And so extenuating circumstances are usually unforeseen and unpredictable. That should be looked at. And, I have to, as a landlord, prove that. I have to provide whatever records I need to show that it was outside my control, not predictable, and that I had no other choice. And if I'm not successful, then the risk is that I have to compensate 12 months rent. The legislated compensation is 12 months rent to the tenant. And so not here with moving in, but there's a similar provision when it comes to the renoviction. And so if someone decides that it's too costly to renovate after all and sells, they're putting themselves at a similar risk because that's something they're deciding and something that should have been foreseen because you do budget out. Whereas something that's unexpected, maybe my moving in, I have to go to continued care. Maybe I'm a little bit getting on in age or whatever my situation is. I can no longer reside there. That's something that would be more of an extenuating circumstance. So it's really about the predictability. And then, of course, it's case to case based on the proof I provide to defend myself.
Beautiful. Thank you so much, Leon. This next question is for Lisa. And Lisa, the question is, my roommate, who is not on the tenancy agreement, failed to pay rent. I gave him a month's notice. Sorry, I gave him a month's notice to leave. He's not leaving or paying. I've contacted the RTB and they say he's an occupant and not a tenant, and so they have no jurisdiction. The police tell me that they won't get involved because it's a civil matter. Can I change the lock? What other options do I have to get him to leave?
Yeah, great question. And the residential tenancy branch can offer a lot of resources for disputes as between landlords and tenants, but they don't actually tackle disputes between roommates. When you have a fight with your roommate, you are not going to be making an application to the branch. They cannot help you. And so you're left with a couple of different options. So if you have a monetary fight with your roommate, then you might want to make a claim at a tribunal called the Civil Resolution Tribunal. And that's an online tribunal. They have the ability to decide contractual disputes between roommates. So if you've struck an agreement with your roommate and they've agreed to share in the rent, and they're not identified as a tenant under the lease, they don't owe the landlord any money, they just owe you money, then you might want to pursue a monetary claim at the Civil Resolution Tribunal, or CRT for short. They can help you if your claim is $5,000 or less. If it's more, then we're off to small claims court for a monetary claim, and they have jurisdiction up to 35 grand. That would be a pretty expensive rental if that's what we were talking about here. With respect to regaining sole possession of that property, so booting your roommate out, neither the Civil Resolution Tribunal or the provincial court can help you. That's a Supreme Court matter, and that's complicated. So anytime you're in a fight with a roommate and it looks like you have an eviction matter, I strongly recommend that you get legal advice first so that a lawyer can have a look and see what kind of contract we're dealing with. But unfortunately, the branch, despite the fact that the act is so long and covers a whole lot of things, it just doesn't capture roommate battles.
Super. Thank you so much, Lisa. We have another roommate question, and this one is for you, Anil. I'm a roommate who is not on the tenancy agreement with the landlord. My roommate, who is on the tenancy agreement, wants me out so her sister can move in. Can she just kick me out like that? If so, how much notice does she need to give me?
Great question, and honestly, there's a lot of similarities with the question posed to Lisa. So I'm just gonna say ditto, Lisa. She did a great job answering it. But to the pointed question of is there a reasonable notice period? Again, the RTB doesn't address these types of disputes, but the CRT has to an extent in terms of the contractual sense, and from that, they've actually determined that yes. When you look at a roommate situation, often there will be an implied term of that roommate contract that provides reasonable notice. And in looking at that, what the implied term could mean contextually, that reasonable notice period could be as little as 1 month, or if we're perhaps in a different setting where there's a lesser rental pool, that might provide for a broader reasonable notice period. But to the extent that can they kick you out just like that? They perhaps could. It'd be not the greatest move, but it could give rise to a claim for damages in contract or breach of contract that could be pursued depending on the monetary value, either the CRT or the small claims court.
Super. Thank you so much, Anil. Lisa, we're moving back to you with a question about disputes. My landlord is trying to evict me and started the dispute resolution process with the RTB. What can I expect at the hearing? Do I need to hire a lawyer?
Lawyers are the worst, aren't they? We don't want to have to talk to lawyers. The process is meant to be very informal, and it's meant to encourage self-representation. With that said, you're allowed to appear at a hearing with an advocate or a legal representative. You don't necessarily need one. I always ask myself, is my question complicated? Do I need help? Can I present my case on my own? Do I know my case? And if you struggle with answering those questions, then you might want to get legal advice out the gate. Getting legal advice doesn't mean necessarily retaining a lawyer for the hearing. So keep that in mind. So you might want to get advice before you've actually attended the hearing in terms of help preparing your material and organizing yourself. But you don't necessarily need a legal representative with you there. What to expect? It is fast, everybody. So you've got 1 hour typically before the branch, 60 whole minutes to get to know your arbitrator and for your arbitrator to get to know you and your claim. So In terms of some tips, make sure that you abide by the documentary filing deadlines. Make sure you provide your documents in an organized and a clear way so that you can explain your case easier, so that the arbitrator can understand your case. And it just helps streamline things for this hearing. And for those who have never attended a hearing before, it might shock you that it's over the telephone. So that's another added struggle or challenge, because you can't actually see each other. You only hear each other. And there's a urge to talk over each other and to respond right away. And hopefully we have rules of procedure at the branch. So if you are on your way to an RTB hearing, I'd highly encourage you to look at the RTB website. They've got lots of information and policy guidelines that might answer your question and determine what you need for your evidence for your claim or how to defend against the claim. And then they also have rules of procedure, which says to me how my arbitrator might run the hearing. But by all means, make sure that you organize yourself, whether or not that's with the assistance of a lawyer or whether you're doing it on your own. Keep organized, stay on track, and you'll find that that 60-minute hearing is all you need to get through it.
Amazing. Thanks so much, Lisa. This next question is for you, Michelle. My tenant finally agreed to move out, and we both signed a mutual agreement to end a tenancy. We have an RTB hearing scheduled in 3 days. Should I cancel our hearing date with the RTB?
Well, you could cancel the hearing if you're confident that you don't need any support. You know, you've sorted out your dispute and you're good to go. So you don't need any help from the RTB to end this tenancy. You know, and this is really when you have no doubt that the tenant's going to move out according to your agreement. But you may want to go ahead and attend that hearing because arbitrators are willing and able to assist the landlord and tenant in this case by putting their agreement into a decision, which makes the agreement official and enforceable in court. So we call this a settlement agreement, and an arbitrator would issue that just like any other decision, except that it's the landlord and tenant themselves who have decided the terms. The arbitrator can give an order of possession to back up the date that the tenant agreed to move out. And if there was any agreement about money, the arbitrator could also issue a monetary order as part of the settlement. And this really makes, really solidifies your agreement. And should somebody not follow it, then the other party doesn't have to come back to RTB to then try to, end the tenancy because the agreement broke down. So to make this happen, when you get to the hearing, the applicant can just, right off the bat, tell the arbitrator, we've resolved this, but we would like you, if you would, to please make our agreement official. And as long as both parties are there, showing that they voluntarily agree to this and want to resolve the dispute this way, absolutely, the arbitrator is going to record those terms for you and issue out that settlement as a legally binding order of the branch.
Super. Thank you so much, Michelle. This next question is for Anil. Anil, after 2 months of not paying rent, the tenant moved out. I never did get around to conducting a condition inspection when they moved in, but they owe me way more money than the initial deposit. Can I just keep the deposit?
Great question. And so before I get to it, perhaps just a little background with the condition inspection report. Often, or it should be done, that a tenant and landlord should get together at the commencement of the tenancy to effectively do a walkthrough of the unit. And the condition inspection report provides for a snapshot in time as to the condition of the unit upon move-in, so that everybody knows what they're getting themselves into. If there's any major damage, this could be listed on the report. And the report, which is standard form from the tenancy branch, provides a nice laundry list of rooms and areas that you can identify and that you could list and perhaps provide notes on the condition of those aspects of the rental unit. So ideally, you complete this. However, in this scenario, they haven't, and I'm going to assume they just moved out and there's no order of possession. There's nothing forcing that person to leave. They just walked away. And so, going back to Lisa's point at the very outset, she falls asleep by Part 4 of the Tenancy Act. Well, Section 24, subsection 2 is before Part 4, so she probably read it, as I have, in preparation for today. And if you read it, it'll say, I'll just read it verbatim. The right of a landlord to claim against a security deposit or a pet damage deposit, or both, for damages to a residential property is extinguished, and that's with emphasis, if the landlord's does not complete the condition inspection report and give the tenant a copy of it in accordance with the regulations. And I think that provides almost for a full stop. A landlord kind of just loses that right. They could try to pursue damages, but it's going to be an uphill battle. The best evidence you would have at the outset is a snapshot of what the unit looked like when you first got there. And without that, it's, an evidentiary basis is pretty hard to prove.
Gotcha. Thank you so much, Anil. Highlights the importance of doing that initial inspection report at the outset. This is our last prepared question. Then we're going to turn to live Q&A. So this question is for Leon. Leon, the question here is, I am a homeowner with a rental suite in the basement. My tenant wasn't paying rent. I got an order of possession from the residential tenancy branch upholding my eviction notice. My tenant won't leave. Can I change the locks or turn off the water?
Yeah, it's a great question. We get this question often, oddly, or maybe not, at the residential tenancy branch. So the answer is no. You cannot change the locks or turn off the water. A landlord who has obtained a residential tenancy branch order will seek a writ of possession from the Supreme Court to have that RTB order enforced. So if it's an order of possession, then you're going to be seeking a writ of possession from the Supreme Court, and you're going to hire a court-appointed bailiff to do the muscle work. If you do it yourself, you're taking the law into your own hands. You could be creating liability for yourself. So it's not something you want to do. And with regards to the tenant who doesn't want to vacate, and they're aware of the order, they've been served, well, the landlords can still apply for compensation to recover the costs of hiring the bailiff and removing the tenant. And that's something that exists. And I know, as Anil had mentioned, sometimes it's a situation where the tenant has taken off, right? They might, or they decide to take off at a certain point. It may be difficult for a landlord to recover that amount. However, it's not uncommon for us to get calls from tenants who are trying to figure out what's going on because their wages are being garnished. And then we look into our system and find a 2014 monetary order in favor of a landlord. So these things do follow you. So if you're a tenant, you want to make sure that you figure something out. And if you're a landlord, just to not be completely discouraged with that respect.
Super. Thank you so much. So turning to live Q&A, I'm going to read out, there are a couple of questions that are similar. So I'm going to read two of them and then turn it over to our panel. The first question is, and it's received the most upvotes, please can you explain how a person can or must prove that they have been wrongly evicted using the family use eviction notice, i.e., but they will not live here. And there's another question that I think is similar, which is, or related, what if you are evicted for family use, you do not dispute it, but then you discover afterward that the family never moved in? Is there any recourse? So I would love to know your thoughts on this. Would anybody like to volunteer as a starting point?
Yeah, I can start. No problem. So how do you prove it? Well, there's certain fail-safes in the Act, and this is all under Section 51. So the first fail-safe is subsection 2 of Section 51, where the compensation, legislated compensation, is found, and it does put the onus on the landlord to prove that they've fulfilled that stated purpose. So there's a little bit of a sway from the natural order of things, where if I'm seeking compensation, normally in civil matters, I'm going to have to prove my claim. And here, the onus is on actually the landlord to prove that they've moved in. And so that's something to work from. Practically speaking, most things are pretty easy to prove now in our digital age. We would imagine that a landlord who would re-rent a property instead of moving in would probably publish that, list the property or so on. So those types of elements can be brought into proof. And as far as not having disputed and then finding out that the landlord hasn't moved in, well, it's kind of a twofold protection against landlord abusing that mechanism, in that the tenant can always dispute the notice from the onset. If they have this idea that maybe landlord's lying, or they have multiple properties, won't move in, they can dispute it. And then, of course, the landlord will have to show the reason behind their notice at the hearing. If they don't do that because they're in good faith, and then they have proof that the landlord hasn't moved in, then they can, of course, go after that legislated compensation. So it's kind of a twofold protection for the tenant.
Super, thank you. And would anybody like to add anything?
I think one thing to keep in mind is that your arbitrator, and keep in mind they're under a 60-minute interaction with you typically, they need to be convinced on a standard called the balance of probabilities. So more likely than not, that's the standard. So we're not looking at the criminal standard beyond a reasonable doubt. It's just, is it more likely than not that the landlord did fulfill the notice or didn't fulfill the notice, or whether or not there's an extraordinary circumstance that would absolve the landlord from having to pay the penalty. So keep that in mind. It's a lighter standard than when we're dealing with a criminal proceeding.
Super, thanks so much, Lisa. Another question here, and again, I will leave it to you to decide who's best suited to answer. When a mutual agreement to vacate in 7 months is signed by owner A, and the property is then sold to owner B, does that agreement carry over? Michelle, I see you nodding. Would you like to answer?
I would say so, yes, because the tenancies continue through change of ownership. So my gut reaction is yes, but I'm open to be, challenged on that.
Your gut matches my gut, Michelle. So, so there we go. So a purchaser steps into the shoes as a former landlord. So if your mutual agreement to end tenancy is effective after the purchaser takes possession of the property, they essentially inherit the contract. So it doesn't matter that the landlord has changed hands. The definition of landlord under this very, very long act that I've encouraged us all to read when we have insomnia defines landlord to include people who inherit the property as well. So so that purchaser would be bound by the mutual agreement to end tenancy. You're not off the hook, tenant, if you've signed on to a otherwise valid agreement.
Thank you very much.
Can I just add to that? Sorry.
Oh,
please.
Don't mean to interject. Yeah, it's also important, just because we're on the topic of changing landlords. There's no requirement to sign a new tenancy agreement with the new landlord. But if you do sign a new tenancy agreement with the new landlord, that could have an effect on that original mutual agreement because the parties' names will change. So just something to look out for in those types of situations.
Great. I have a question here. It's not a legal question, but it's a question about proportionally over the last year, what percentage of RTV hearing results were in favor of the landlord versus the tenant? Do you have any stats on that?
I have not looked at that recently, but this is going off the top of my head, it's typically about even. There isn't if you look at the stats, you're like, wow, look at all these landlords getting pro decisions. I mean, Leon, is that your experience when you've seen?
Yeah, it's 50-50. No
yeah.
doubt. It also depends on what's claimed, right? There are a lot of claims are, you can categorize them. You have claims that are for current tenancies. You have claims that are monetary claims for past tenancies, so damages or return of security, and they might have different results. And then you have claims for current tenancies that are very specific to end of tenancy, so eviction, right? Or emergency repairs, right? The security of the rental unit. And from what I understand, it's all pretty much 50-50. But
yeah, I mean, if you take something, a kind of a black and white dispute like unpaid rent, landlords are very successful because rent must be paid. And if they can prove that the tenant did not pay the rent, they will be successful.
Okay. Just to jump in there, once you do get a RTV decision, that's not the end of it. There are opportunities to review those decisions, through the RTV's own process, if there are certain things that occurred in your opinion, or you go to the Supreme Court and you could have it judicially reviewed by a court on the standard pattern of unreasonableness, which is it on its face blatantly just really bad. So despite the fact that there might be a 50-50 split at the first instance, it doesn't necessarily mean it could be upheld upon review, and that might change the balance. And not to put Michelle early on the spot, but is there a statistic on how many cases get judicially reviewed?
I'm afraid I don't have those numbers, but I know that the success rate of the judicial reviews is very low.
Yeah, I
Very
would
low.
agree in that, we see the judicial reviews come into our service, and it's not very often that we get we see that come by. So I'd probably say maybe I want to get, I'm just speculating here, maybe a dozen per year max.
Yeah, that the BC Supreme Court upholds and quashes. Yeah, I would think that might even be a high estimate, Leon.
Yeah, it's a high estimate. That's the amount that probably go across our desks, and then how many are
Yeah.
successful is hard to say.
I think if the individual who asked the question is trying to hedge their bets, so how likely will I will I win at the branch? One of the useful tools on the branch website is a decision finder, so you can actually look at published decisions. Now, all the parties' names are redacted apart from corporate names, but it gives you a sense as to how other disputes fared when they went before a branch hearing. Now, the arbitrators aren't bound to follow each other's decisions. They all make their decisions based on the evidence and what was presented to them in each case. But if you're wondering if your case has gone before the branch and how that case was decided, then that's one place you guys can look, which might give you a little bit of a glimpse.
Super. Thank you so much, all of you. Here's another question. If you've received an NET for landlord use of home and have settled outside of the RTB with your landlord, do you then forfeit your rights if you subsequently learn that they, in fact, aren't using the home for family use?
Paul, I'm assuming you mean notice to end tenancy.
Yeah, NTE.
I'm assuming that's what's meant here.
Yeah.
So I'm not cool enough for that.
I didn't know.
I was going to say I'm translating it in my head. I'm looking at Michelle as well, and I'm like, am I missing a acronym?
Perfect.
And sorry, Paula, I was more
absolutely
occupied with the NET component. So
thank you. So if you've received notice to end tenancy for landlord use of home, and you settle outside of the RTB with your landlord, do you then forfeit your rights if you subsequently learn that they in fact aren't using the home for family use?
It depends.
This is exactly, Leon, I was going to say the exact same thing. How brutal are we?
But there's one critical thing. You must have been given that 2 months notice by the landlord. So the compensation flows from receiving the eviction notice. So if you decided to leave without receiving an official RTB eviction notice, you are not entitled to compensation.
Yeah, I think it all depends on what the terms are in the mutual agreement to end tenancy. And one of the things I always encourage landlords as well, if there is a inkling that you might not follow through with what you've put on that notice and you want flexibility and you might be paying the tenant a little bit more money for that flexibility, then it needs to be very, very much spelled out in the notice that you are given clearance to use the property for any other use later. Now, caveat there. You're not allowed to contract out of the act either. So you can't just have a tenant sign an agreement that overrides their rights or obligations. And if you are entertaining a very unique end to the tenancy in exchange for compensation that they might otherwise not be entitled to, so more than 1 month's rent or what have you, be very, very explicit in your agreements that people should seek legal advice, that they are not obligated to enter into this agreement, that's a genuine settlement, that people understand what they're signing, because what you don't say and do can come back to bite you at the branch.
Fully agree. And if anyone is looking for on our site a reference about notices, Policy Guideline 11 is pretty good for that, about withdrawing a notice, because you really do want to punctuate every part, landlord and tenant, so that nothing lingers. And of course, I agree with what Lisa said earlier on. If it's a hard question that you can't answer, maybe it's time to talk to a lawyer.
Oh, no.
Oh, no. Okay, so I have another question here. I'm going to read it out. I am a tenant since 6 years of the same place. My landlord increased the rent last year by 35%, saying my rent was very below the current market rate. I had no option because I knew I would be served with an eviction notice. There's no other house available even after the 35% raise. I agreed, and the landlord wants to increase by another 18% for the next year. What do you do in such a situation?
I love everyone's expressions as Paula's reading the question, like disaster.
35% is a lot.
You
So,
can't increase the
yeah.
rent beyond the statutory maximum. So you can't negotiate out of tenants' rights under the Act. You can't avoid the rent increase maximums. You can strike an agreement. Now, the Act actually allows you to agree to an additional rent increase. But again, very, very strong caution to landlords. You need to have explicit terms acknowledging that tenants do not have to agree to this. And you should have some reason as to why you're asking for that additional rent, whether or not it's to make an improvement that you've agreed. So you've agreed to provide the tenant, hard surface flooring instead of the carpeting that's there, and the carpeting is still fine, etc. You might be striking the deal, but being compelled to pay more rent on threat of eviction, if that threat isn't supported by the Act and it's in way excess to the maximum rent increase, doesn't lead to a viable eviction. And keep in mind, tenants, you have 2 years after the end of your tenancy to make monetary claims against your landlord, and vice versa for landlords against tenants. So you might realize a year after your tenancy ends that, oh my gosh, I was overcharged rent for a period of years. You have the ability to go back and get a monetary claim for being overcharged. So something to really keep in mind for both landlords and tenants.
Super.
I'd like to add also, the caution is correct. Now, if there is a situation where you want to agree to go higher, maybe this is something where you're way below market and you're okay with that. As a tenant, you can agree. That's in writing, separate document. As Lisa said, you still have to receive the RTB7 form and the proper timing. And for a tenant, that may be also an opportunity if you are stable and you want to, your fear is stability, maybe trying to set out for a 1-year term or something to that effect, right? Sign an agreement that has a term that gives you that stability, because most BC agreements that have been on long term have already rolled over to the month-to-month periodic tenancy that we're familiar with.
Super. Thank you so much. Here's another question. If a tenant moves out and there was minor damage done, like a scratch in a door, can the landlord keep all of the security deposit? If not, how do you calculate how much of the security deposit the landlord can keep?
I could feel this one if there are no volunteers.
Please, let's hear it.
So, I mean, it's good that we're getting questions about security deposits, and I think there was one for Anil earlier about rent. There's one thing to be really aware of, is that the tenant has to set off the whole return of the deposit process by providing a forwarding address in writing. They have a year to do that. If they fail to do that, that deposit becomes the landlord's. So that's from the end of tenancy, or the date that they, from the end of tenancy is 1 year. And so that's a first factor to look at. Then there's what we call reasonable wear and tear. And so under Section 32, the tenant is not responsible for reasonable wear and tear. It's something that happens with the deterioration of different building elements that is natural. So a little scratch is unlikely to be something that the landlord can claim for. But if they did decide to claim, having received the tenant's notice of forwarding address, they'd have to file through for dispute resolution. And so hopefully in these types of situations, both parties can come together, and maybe the tenant signs off on a $50 portion that they'll allow the landlord to keep, and landlord gets that permission in writing, and then it all kind of makes its way out, because it is a $100 filing fee to file for dispute resolution. So for a scuff, it's pretty costly.
What if it's a really big scuff, Leon?
Yeah, if it's a big scuff, it's probably not wear and tear, right? And there's that. There's, someone's playing, move the piano around the living room and has completely ruined the floors. That's something they'll likely have to repair or compensate for.
Yeah, and as far as calculating the amount, that's an arbitrator who would do that when the landlord filed to keep that money, if you didn't agree to it, and the landlord has to prove the cost. So one, they have to prove that the tenant breached the act, they damaged something and didn't repair it, and then they have to prove the cost of that. So a minor scratch, they would have to prove the cost of how they are repairing that, and if they're unable to do that, they won't get any money.
Super. Thank you. We have time
Sorry.
for one.
I actually was going to add one quick thing, just being mindful that when you're dealing with the return of a security deposit, you have to be kind of timely with your next steps, because if you fail to act within the 15-day time limit, you're going to end up paying that tenant double. And that's that's, it's injury to your own dignity at that point.
Okay, super. I think we have time for one last question, sort of. We're gonna have the question. If a tenant is given a 2-month notice for landlord use and the tenant files a dispute against the notice, I read that the notice is put on hold, meaning that the tenant does not have to move out until a dispute hearing. Can the tenant then change their mind and choose to honor the notice and move out, but refuse to withdraw the dispute? Then there's follow-up. When the notice is on hold, pending a dispute hearing, rent payments are expected to continue. Can a tenant say they changed their mind and will honor the notice without withdrawing the dispute and be within their rights to withhold rent for the last month while a dispute hearing is still pending and the landlord has not given consent for the 2-month notice to be observed without withdrawal of the hearing? So it's a long question, and I'm wondering, Michelle, you seem to be nodding, so I'm wondering if it's a question that you're comfortable kind of addressing. We only have a couple of minutes left, so even
I'm trying to follow it along. That 1 month of compensation can be tricky. Hopefully landlords and tenants are talking, and they get that 1 month typically for their last month. It should be agreed to the landlord and tenant of when that 1 month compensation is. If the tenant doesn't withdraw their dispute, the landlord should still attend the hearing, whether or not the tenant's going to show up and explain to the arbitrator what the situation is. A tenant who files to dispute a notice and then doesn't show up at the hearing to pursue that, will have their application dismissed. And the Act provides for any time an application is dismissed, when a tenant files to cancel a notice, and if that application is dismissed, the landlord gets an order of possession. So if the landlord shows up, they get their order of possession, and that tenant's going to be out of there. I'm not too sure about the dispute about the 1 month compensation. That's a tricky one. Ideally, the people decide what month that applies to.
I can answer that.
Okay, great.
Thank you. And as you do that, Lena, I'm just going to share the final screen because we are at time, but please go ahead.
Yeah, so with regard to the 1 month compensation, if you're disputing the 2-month notice, you're disputing the validity of the notice. Mm-hmm. And the 1 month compensation is for proper notice. It's implicit in the reading of the Act. So if you are a tenant who's disputed a 2-month notice, the hearing, and you're right to say, Paula, that the notice's validity is on hold until the arbitrator makes a determination. And so sometimes what happens is that 2 months has already elapsed. And so a tenant who doesn't continue to pay rent with the hearing pending, they can be exposing themselves for receiving a 10-day notice for unpaid rent. So you can't have both sides of the coin. You either are disputing the 2-month notice or you're not. And if you're not, that's fine. Now, I think the question was really about changing your mind. And changing your mind about disputing a notice to tenancy, you do have to get your landlord's written consent to withdraw your application. That's something that's required under the rules of procedure. When a dispute deals with notice to tenancy, the tenant applicant has to get their landlord's consent if they're going to try and withdraw. If not, we won't withdraw the hearing, which is what Michelle hinted towards. And then parties should be working together. If you're going to be withdrawing and you're going to be figuring this out, then everything should be in writing and working together to make sure that, there's nothing left on the table, so to speak.
Super. Thank you so much. We are at time, and I wanted to thank everybody who joined us here for today's webinar. These are excellent questions. Thank you so much for your participation, for sending them in. Thank you so much to our panel, Leon, Michelle, Anil, Lisa. You have been incredible. You have answered these questions beautifully, concisely, and this webinar has provided so much information. So thank you so much for being here today.